Last week on the Al Nicoletti Show. Let's welcome him to the show. What's up, man?
The more inbound a lead is, generally the better quality that lead is. The other thing that happens, though, as you move from outbound to inbound, is usually the cost per deal increases across those channels. So just when you're thinking about like inbound, outbound marketing, I think that's a great framework to think through it on, is like which, do you want to have your marketing expense, or do you want to have your operational expense? Do you want to, use your money towards your favor, or do you want to use your time towards your favor to get in deals?
When you're advertising, they have an issue and they're coming to you. What's so great about that, quality of leads just jump up.
The fact of the matter is, what somebody types into Google is more predictive of their future behavior than almost any other data point you could ever have. In this industry, though, the location that you target is the product, because you're going to buy that house. So like rule number one is that the wider you go in your locations, the cheaper your cost per lead will be.
I didn't know about this until a couple months ago. Like, you pick Florida, you can get things in the Panhandle, the South Florida. You can like pick just one market. So if you really wanted to just move everything to like Tampa, you can just plump all your money right into the Tampa market. The cost just goes up because now you're just going in that one saturated market.
What you have to think is like, okay, I'm targeting all of Florida, but can I do deals in Georgia? Can I do deals in North Carolina? And if the answer is yes, then you're not targeting enough. But then at the same point, if you don't want to do a deal in the middle of nowhere, Palatka, Florida, don't target it, because you're going to get leads from there. Because what happens actually with PPC, your ad spend will naturally flow to the least competitive amongst the areas that you're targeting. And the reason that happens is because Google likes to optimize. Like, you're going to tell Google, like, I want as many leads as I could possibly get. And Google's going to say, okay, great. I found some of these areas here where nobody else wants a lead. So I can actually get them pretty cheap for you. I'll get you all the leads from that area, and then you'll get as many leads as possible, which is exactly what you wanted.
I didn't know that that's what Google would do. I think it's fascinating. I'm sure we could dive deeper even on that part alone. We're going to leave it right there. Brandon, so much valuable information, golden nuggets, things that people can expand on when they want to do more inbound marketing with PPC. Thank you so much for coming on and talking about this.
It's a great experience, Al. Love the show. Thank you for having me.
Awesome jam-packed episode with Brandon Bateman last week, talking about inbound marketing, how investors and people that are just doing deals can really leverage Google PPC, pay-per-click, and get more inbound deals, right? There's a lot of things that people don't know when getting into inbound marketing. And if you are not privy to that market, right now, inbound marketing is a hot topic. I mean, everybody knows outbound with the cold calls, direct mail, but the inbound where people are motivated, they're reaching out, they're trying to get in touch with you. If you missed any of that episode, Brandon, you got to check that out. Just tons of information, things that I had no idea about. A lot of people had no idea about. And there's people out there that are doing Google PPC all the time that didn't even know. So check that out. And you can find all the content of the Al Nicoletti Show on all the platforms. We'll put up the QR code and find out all of our stuff. We're all over the place right now. And another thing, if you are really enjoying the show and the episode, feel free to share it. Feel free to share it on YouTube and Facebook. And, we get such amazing value by doing that, giving more to the community, right? If you find value in it, someone else will. And we love it and appreciate it. And tonight, we have another amazing episode with Angela Langlotz, the trademark doctor, a trademark and copyright attorney. I mean, she knows her stuff when it comes down to this. And I'm blown away by her knowledge of trademarks. I remember like 5 years ago, I was like, what is all this stuff with trademarks and TMs and the copyright logo, and when can you like use it and how long can you sit on it? I mean, there's so many things that Angela knows when it comes to this, and we're going to dive in on that. And before we get there, I just got to say, for opening thoughts tonight, the business is out there. A lot of people are trying to get deals. They're trying to get business. They're just trying to get more and scale their business. And a lot of people are just leaving deals and opportunities on the table, and they're not picking up on it. They're not responding to emails. They're not responding to phone calls. They're not responding to the gold that's out there. And anybody that is just trying to do more, go back to your inbox. Go sift through it. Go really slow, and you'll find that you're missing out on opportunities or connections or follow-ups. Don't miss out on those. The business is there. It's amazing the little things that you can pick up on that will help you just generate that next big lead. And I can tell you, for me, I'm always monitoring the email. I'm always looking at the inbox because I know the power of what that can do when you follow up like that. So don't miss that. Check that out right there. All right, everybody, I'm ready tonight. Happy Wednesday, everybody. Well, another Wednesday night. Man, the week's flying by. The clock went forward. Everything's flying. I'm ready. Pen, paper, new colors of the set. Mike and I were just like, let's just do new colors. Let's rock this thing. Hey, everybody. My name is Al Nicoletti. I'm an attorney here in Florida, and welcome to the Al Nicoletti Show, where I bring on real estate super investors, rising rock stars, movers and shakers, and leaders of clubs in their communities that educate, entertain, and inspire all things on Florida real estate. And always, we are going to bring in the best of the best in the industry. Whether we're talking about branding, commercial, Airbnb, trademarks, you name it, we always want to bring in the people that can provide the most value to you on how you can take your company to the next level. On my show today, Angela Langlotz, the Trademark Doctor. This is going to be an episode you don't want to miss. Get your pens and paper out because this is going to be important for your brand and for what you do as a business. So without further ado, let's welcome Angela to the show. Angela, we did it.
Hey, Al.
Hello.
It's nice to be here.
Welcome to the show. Thank you for taking the time to do this. I think this is a fascinating topic, and we just got to dive in on this because there's so much to unpack when it comes to trademarks and copyrights and a lot of things that people got to know. So let's begin. What is a trademark and how do you even use them?
Well, a trademark is basically a monopoly on the use of a certain symbol or word or phrase with whatever goods and services are listed on the trademark application and any quote unquote related goods or services. Now, what's related? Well, it kind of depends on what the goods and services are. I know everybody hates it when lawyers say it depends, but that's really the case. So, for example, in the real estate context, if you have a tagline or a slogan or something catchy that you call yourself, that is subject to being trademarked. So you can actually register a trademark for any of those things. And I have, in fact, registered a whole bunch of different trademarks for my clients that sell real estate.
Great. And trademarks is really important, right? A lot of us have businesses, podcasts, content, video, our brands, our logos that are out there. And that all really is that identifies us in our business. But
exactly.
What are we doing to protect that, right? So let's go with some of the basics because we'll break this down one by one, which is what can you register a trademark for?
Well, according to the trademark law, you can register a trademark for anything that is distinctive. In other words, that distinguishes you from your competitors. So a trademark can literally be a color. It can be a sound. It can be like that bong, bong, bong for NBC. That's actually a registered trademark. Strange, but true. You can register slogans like just do it, or symbols like that Nike swoosh. That's registered as a trademark. So you can register a trademark for any, we call it a device, right? For anything that distinguishes your goods and services from other people's goods and services, that's a trademark. And if it is distinguishable, then it's capable of being registered.
Yeah, you brought that up in the onboarding with me, which was the concept of being descriptive versus distinctive when it comes to trademarks. And there's a fine line between those concepts. What is the difference between the two?
Well, a descriptive trademark, which is still registerable under certain circumstances, and that's a little rabbit hole that we probably don't want to go down. But in general, descriptive trademarks, that's a mark that describes the goods and services, describes the end user of the goods and services, or describes some inherent quality of the goods and services. For example, If you are selling ice, right? Like you've got a little cooler and you're selling ice, you cannot have the trademark cold for ice, because cold is an inherent characteristic of the ice, right? And everybody has a right to say that their ice is also cold. So if we give you a trademark on cold for ice, remember, a trademark's a monopoly. So now we're preventing anybody else from using the term cold with ice, right? So we don't like, in general, descriptive trademarks. They're heavily disfavored. They are in some circumstances registrable, but I really encourage my clients to come up with distinctive trademarks rather than descriptive trademarks.
Yeah, and being very careful on what that is, because a lot of people have a lot of ideas that come to mind and think, hey, we can use that, and then they just do it, right? And
Right.
they don't realize that that's already something that's being used, or just it's a common word or a common theme, and having that distinction between the two is really important. Let's also back this up too. So if somebody has a mark, or somebody has that brand or logo or just catchphrase, right?
Mm-hmm.
One of the first things you have to do, right, is see if that's even an available term that you can have trademarked, right? Like you have to see, is this something that's available I can do a TM for or a copyright on, right?
Well, let's back up a little bit and let's make a distinction between copyrights and trademarks. A copyright is for any sort of creative work. So it might be your ad copy, it might be your website, it might be your services and procedures manual, right? That's all capable, because it's creative, it's capable of being registered as a copyright. What we've been talking about so far is trademarks, which is protection for your brand or something that distinguishes your goods and services. So we don't want to get the two mixed up. There is a little bit of overlap, but I think it's really important that we keep them separate, because people get really confused about those sorts of things. So we're talking about trademarks right now. And you asked me a question and I forgot what the question was, Al.
Well, like we'll talk about the availability, but actually,
the availability. Yeah, the availability of a trademark. Yes, the first thing I do when a client comes to me and says, Angela, I'd like to register this trademark, the first thing I do is I do a quick search of the trademark database to see if it's even available. It wouldn't be available, for example, if somebody else were already using something, we call it confusingly similar to what my new client wants to use, right? So we have to go look and see if somebody is already using something very similar. If that's the case, then we need to do a deeper investigation. Who was using it first? Where were they using it? So we can go down that rabbit hole if you want to, but in general, we need to make sure that before you adopt a trademark, you need to make sure that nobody else is already using it. Because if somebody is, and then you start using it, you're actually infringing their trademark.
And that's a whole thing with the infringement battles and litigation. And we can kind of save those stories to the end, because I'm sure a lot of people would be intrigued to hear like what you've been through with those battles.
Oh, yeah, everybody loves the attorney war stories, right?
Yeah, they always do. We'll get to those. But you brought up something interesting about a lot of people muddy the water between a trademark and a copyright. And I
it's
think
very common.
Just to make it very clear for the viewers and listeners, so let's make if we can, just an example itemized list of things that can be copyrighted versus things that can be trademarked.
Okay, so when you think of trademark, think about brand protection. When you think about copyright, think about protection for anything creative and written, or creative and filmed. Like, for example, Al, you and I are both authors on this podcast. It might be your podcast, but I'm helping you create it too. So we're both authors. We both have copyright rights in this podcast. It's a creative work. So any photographs that people take, for example, those are considered creative works. Those are subject to copyright. Your sales copy. Okay. So if you have like some ad copy that you put out, maybe especially long form copy, things like that are subject to copyright. What else? Your blog, like maybe you have blog articles or creative things that you've written for your blog, that is capable of copyright protection. But short phrases and individual words are not covered by the copyright law. Why? Because they're considered insufficiently creative. Okay.
Interesting.
I know.
But like sounds and phrases and like logo designs and things that are recognizing your brand, those would be more on the trademark side. But the creative works is going to be the copyright side. I think that's very clear, right? Because a lot of people do muddy that water, and they'll put TM on something that is a creative. Not working that way.
I mean, nice try, but not quite right.
Yeah, let's break down something on the trademark side first, and then we'll move to the copyright. So on the trademark side, how is one really protecting themselves on the sounds, the phrases, making sure that somebody's not going to come along later and either use it or implement it or just come along and put the TM and then they're using it? Like how are people going to get protected? They came up with something, now they want to keep that.
Well, they need to register the trademark with the Patent and Trademark Office. And the reason why we register is because then your trademark is in the trademark database for other people to find and avoid. So that's one reason to register. The other reason to register is because now you've got this trademark certificate and it says, hey, this is my trademark and here's the trademark and here's the date that I registered it and here's my date of first use. So there's a whole bunch of information on this trademark certificate that tells a whole bunch of things about your trademark, including the goods and services that the trademark applies to. So if somebody else is using your trademark, you can come and wave that in their nose, under their nose, in their face and say, hey, listen, you are violating my trademark rights. Here's my registration. Please stop or I'll sue you, right? 9 times out of 10, actually more like 99 times out of 100, they'll go, oh my God, I don't want to get sued, so I will stop. But if you don't have a trademark registration, all you can say is a wimpy, hey, I was using that first. And you have to go through a whole bunch of rigmarole to prove that you were the first user, that you have better rights than the other guy, that you were actually using it as a trademark, the goods and services that you were using it with. It is a whole bunch of stuff that you would have to prove, or you can, just stop using the trademark, but you got the trademark in the first place, or you started using it, even if you didn't register it, because you liked it. You don't want to give it up, right? So if you like it and you want to enforce it and you want to stop other people from using it, then you want to be able to say, hey, this is my trademark. And that's what a trademark registration does.
It's very important, right? Protecting yourself. And something that you talked about with me too is like making sure you're very careful with plurals and singular when doing trademarks. Can you elaborate on that? Because I know you have a famous saying when it comes to doing those kinds of trademarks.
Yeah. Sometimes people come to me and they're like, Angela, I got this great idea for a trademark. There's somebody else who's using it, but I'm putting an S on the end. And I'm like, oh, no. We can't do that. If they have a trademark registration, you putting an S on the end for the same or similar goods and services, that's still an infringement. So please don't do that. Or sometimes they'll come to me and they'll say, Angela, so somebody else is using this trademark. It's like crazy, whatever, but I'm spelling it with a K. And I'm like, no. Crazy with a K is still crazy, right? So that's what I tell my clients. It's like, look, if it sounds the same, then it's the same. You can't just say, well, I'm spelling it with a K, or I put an S on the end, or mine has a dash. No. Those are all going to be considered the same. Why? Well, Al, because when we use trademarks, we hear them. We see them in print maybe sometimes, but we also hear them, right? Like, do you know the difference, Al, between crazy glue with a K and crazy glue with a C. It's still crazy, right? Like you can't tell. So those two marks would be considered the same, spelled with a K, spelled with a C. Crazy with a K is still crazy.
Yeah. And yeah, you have to be very careful with doing that. And people think that's creative, and maybe it looks that way, but it's not going to come across that way legally.
No. I mean, thumbs up for creativity. I love the creativity, but sorry, bad news.
Yeah. And let's talk about this, which is, okay, you want to make sure you trademark the phrase, the sound, but you want to either just put a hold on it, or what you call trademark squatting with the TM.
Right.
Let's talk about trademark squatting. Every time we're talking about squatting, we're talking about like squatters, right?
Right.
But this is a little different. Tell us about like how you can use that, but how long you can use it for.
All right. So, you can't really squat on a trademark, except there is one situation where you can. You can actually file a trademark application based on your intent at some time in the future to use that trademark in commerce. Okay. And you can file the application. Once the application is approved, you actually have 3 years to prove your use. So you can really kind of squat on the trademark application for 3 years before you actually start using it. You have to pay a fee, right? They're going to charge us a fee every 6 months. It's a squatting fee. It's a squatting fee. I just made that up. But yeah, we can hold that trademark application for up to 3 years after we get what's called the notice of allowance, which is basically the trademark office saying, yep, we don't see any problem with your trademark. Just show us your use. You've got 3 years to show them your use. So you can, for a limited time, 3 years post notice of allowance, you can actually squat on the trademark. But if you want the trademark registration, you actually do, before that 3 years is up, have to show use of the mark on the goods and services that are listed in the trademark application.
So not just good enough that you have your logo, you have your sound, and that you just put TM.
No.
Yeah. People think that by doing that, they're just like holding on to that image, right? They're we don't use it.
Yes, you might have common law trademark rights. We can talk about those if you want, but you are not listed in the trademark database. And if somebody else comes along and wants to apply for that trademark, the trademark office does not go out into the world and say, I wonder who else might be using this trademark. No, they look in the trademark database. If they don't find your mark there, they're going to say to whoever applied, yeah, sure, we don't see anybody else using that trademark. So we're going to give you the registration, right? So you have to be careful of that. If you're not in the trademark database for other people to find, you may have to engage in some very expensive trademark litigation.
And who wants to go through litigation? Because that's going to be long. It's expensive. The lawyers make a lot of money, but it's still not going to benefit anybody, right? Because it's
it benefits whoever wins eventually. But yes, it will be protracted, probably on the order of a couple of years, maybe longer. And it will be expensive. Like if you get involved in a trademark kerfuffle legally, plan to spend $10,000 to $50,000 litigating that.
Yeah.
I tell my clients, it's my job to keep you out of court. Right?
Yeah. Right. That's the hope, right? Otherwise you're on the other end going through a whole battle, and a lot of people don't want to go through that.
It's ridiculous. And few people actually have the resources to sustain that sort of a battle. It's very expensive. It's very time consuming. It's stressful. Even if we're only litigating before the Trademark Trial and Appeal Board, we're not even in federal court. It's a little bit less expensive to litigate before the Trademark Trial and Appeal Board, but it's still expensive. It's still time consuming. It's still stressful. And registration is so much cheaper than litigation, Al.
Oh, I'm sure. I mean, it's a way cheaper process to actually make sure you have all the paperwork than go through depositions, discovery, motions,
Yep.
hearings. Who wants to do that?
Nobody.
Angela, let me ask you this. So I remember on our call, you were talking about ownership. Like,
Mhm.
who should own your trademark? This is really
Sure.
interesting. Like, is it through just yourself? Is it through an entity? Like, what do you recommend?
Well, I don't recommend that people own their trademarks just as themselves. And I also don't recommend that you own your trademark in any sort of like real estate operating company. Because what happens on real estate, Al? People trip over things, people fall into holes, uh, all kinds of stuff, injuries happen on real estate. So if your operating LLC that owns your real estate also owns your trademark and it gets sued, guess what? Your trademark owned by the same, entity is now
Looped
up for
in.
grabs, right? So what I recommend is that you form a separate LLC, a separate holding company, and then that just owns all of your intellectual property, right? So when I did asset protection in the early part of my practice many years ago, I used to talk about hot assets and cold assets. So intellectual property is a cold asset. And when I say cold, I mean it doesn't itself generate liability, right? Real estate, I would consider a hot asset because it generates liability. So does any operating business where you're inviting the public onto the premises, right? So anytime you're inviting the public onto the premises of your operating company, you're bound to get sued. Someone's going to trip. Someone's going to, I don't know, about the crazy things that people sue for, right? Dog bites, whatever the heck. So we want to make sure that we don't have any other assets in there that aren't part of that necessary operational asset, right? So we want to keep the trademarks and the copyrights and any other intellectual property out out of your real estate LLC, please, for the love.
Just keep it separate, right? Keep it
Exactly.
separate,
Keep
and
it
that's
separate.
the key. Don't loop it
Yeah.
into all these other things, right? Well,
Right.
yeah, I remember we had Bob Bloom on the show just talking about entities and
Yep.
land and LLCs and the importance of just like making sure like you have those things set up, and like Angela's talking about, don't loop it all into one. That could be a whole thing.
Yeah.
Angela, let's break it up now into copyright section, right?
Okay.
Because that's a great analysis on trademarks, copyrights. So the creative videos. I mean, how many people are doing videos and content,
Yes.
photos,
Yeah.
podcasts, or doing blogs or writing things for their SEO on their website or their
Yeah.
website? What are some things that the steps people can do to start protecting that type of art work and creative work?
Yeah. So you can register all of that with the Copyright Office. The Copyright Office has gotten kind of hard to deal with lately. I don't know. They've gotten super picky. So if you don't file it the right way, they'll send it back. But in general, anything that's creative is subject to being registered. The copyright subject to being registered. What's the advantage to registering a copyright? Well, you can't get into court to sue for copyright infringement, says the Supremes, okay, unless and until you have a copyright registration. So if you want to sue in federal court for infringement, you're going to have to get a copyright registration. How do we do that? You can go to copyright.gov. You can try to do it yourself. It's kind of a clunky website. Good luck. But yes, you can register things like blogs and videos and things like that. When the copyright law was written, we didn't have the internet. Okay. So the copyright law didn't really contemplate a world where things get published daily, right? Like it didn't really contemplate a blog with 300 articles on it. It didn't contemplate, like my YouTube channel has over 500 videos on it. Okay. It didn't contemplate a world where people were constantly putting out new content to register. So it can be a little bit cumbersome to register certain things, right? Like if you've got a real estate course and it's got a bunch of videos in it, you can burn those videos to a disk or stick them on a thumb drive and send them to the copyright office, right? So that's an example of valuable content that you can register at the copyright office. What else? You can, I know that there are some tools where you can like download the whole website, burn it to a disk, and send it to the copyright office. So, that's an example of things, but more traditionally, copyright has been used to protect, like articles, procedures, manuals. I'm just thinking about your audience and the kind of content that they're producing. Yes, of course, you can register copyright for videos. How many videos are you putting out a week? Are you doing like a YouTube short every day? If so, maybe what you want to do is quarterly, like stick all that stuff on a thumb drive and send it to the copyright office. And it gets a little weird too, because when we register copyrights, we register a work. Okay, that's what they call it, the work. A work of authorship, and you're the author, right? Like I'm an author, you're an author, we're all authors. So we have to decide like, what's the work? There are some works that can be bulk registered, like photographs and graphic designs can be bulk registered. I'm not really sure if you have a course, right? Like, so if you have a video course, let's say it's got 10 videos on it and you want to register that, you burn all of those to a thumb drive or a disk, send it into the copyright office with the cover sheet. Okay, fine. But what about your YouTube channel with 500 videos on it? Is that 500 individual works, or is it one big work, right? Like these are some weird things that you have to grapple with for copyright law. I don't really know what the answer is. I'm probably going to call the copyright office and ask them if I have a client with that sort of thing. I haven't registered my videos with the copyright office. You know why? Because personally, I don't care if they share my stuff, because you know what? There's a little footer on the bottom that has my name on it and it's all branded. So if people want to like use my stuff, it's got my brand all over it. Right. So, if you want to, like, you've got the Al Nicoletti show right over your head. So if somebody like steals a clip with your face on it, Al, guess what? Your branding is right behind it. Right.
Yeah.
So share all you want to. That's my motto. So I just put my brand all over everything. Then I don't have to worry about it. They can steal it all they want to. I don't care.
I told people in the beginning, if you want to share the show, share it on Facebook, on YouTube, do your thing.
Yeah, absolutely.
You talked two things you talked about, like the YouTube channel. Like, would you just turn in the whole YouTube channel? I mean, you don't have to turn in all 500 videos. That'd be crazy.
Well, you have to submit them to the copyright office.
That's crazy.
I know, right? I know. So I don't know, like, what I mean, it's okay. Let's do a Fermi problem here. So every video is about 5 minutes long, we'll say, and there are 500 of them. So it's God, like, 2,500 minutes divide by 60. Al, how many hours is that? That's a lot of hours.
A lot.
That's like hours. So what? I mean, am I going to like burn? I guess you know what? Here's probably what I would do. I actually have all of the videos. They're all uploaded to the internet. So I would probably just download them. Well, it would be a lot of discs.
That's a lot of discs or USB.
Yeah. So
Right.
But this is the kind of thing that we grapple with, right? Like, how do we submit it? Because there's actually an file upload system, but for big files like video files, you're never going to compress those enough to be able to upload them. You're going to have to send them in via snail mail. It's all very 20th century.
But you brought up a point about courses. So like in the family mastermind, I mean, there's a lot of coaches, right? A lot of mentors, a lot of coaches, and there's a lot of investors that actually do those coaching programs, mentorships, and they want to protect their works, right? And you talked about a course. That's heavily, they want to protect their work and their knowledge behind it, while some of the knowledge is probably common knowledge to a lot of people, like you said, like just being on the show, this is a creative work.
Right.
So the importance of submitting something like a course and the repercussions of not doing it could be, I mean, huge.
Yeah. Well, I mean, think about all of these pirate sites that basically pirate the courses and then they resell them for like, 10% of what you pay, right? That is that creator is losing a ton of money to that piracy. So it's important to, well, and there are ways to prevent people from like recording the screen and downloading the videos too. But if you want to sue them in court for copyright infringement, you're going to have to register the copyright for those videos. That's just the way
It's
it
just
is.
what it is. Yeah,
Yeah.
it's just the way it is. Well, let's talk about some battles, like on either on the trademark side or the copyright side, right? Like, what have been some of the war stories that you've seen where the repercussions of having not done it, or maybe there's somebody that's going against somebody that's using their trademark and infringing upon it? Like, what happens? What does it really look like in a battle?
Okay, well, some of the saddest things that happen are people who have really good brands don't register, and then they end up fighting with their infringer who is trying to register. And sometimes I just stumble across these when I'm doing something else for a client, right? Like I'll be checking on something in the trademark database, or the client will come to me and they'll say, hey, I'd like to register this. So I won't name names, but these people had a very valuable brand. They had a coaching business and they had been using this trademark for like 20 years. They came to me and they said, Angela, we'd like to register this trademark, right? Let's call it, I'm making this up, let's call it adventure coaching, right? They said, we'd like to register adventure coaching. I say, okay. So I do a search of the trademark database and guess what I find? Some infringer is trying to do an end run around their trademark rights. So a lot of people believe, this is a sidebar, sorry, we're gonna take a sidebar. A lot of people believe that, hey, I don't care, I can steal your brand if I register it first, even though you were using it first. And that's incorrect. Because when you use a trademark, you actually have what are called common law trademark rights. And you have those common law trademark rights in every state and territory where you were actually using the mark. If you have a nationwide coaching business, and adventure coaching was a nationwide coaching business, so they had common law rights throughout the United States. Well, Little Miss Infringer decides, oh, I'm going to go register adventure coaching because I want to use the mark adventure coaching. Okay, so she goes and she applies. I just happened to do a search for my client, my new client, and find her trademark applications, which luckily had not yet been published for opposition. So when they were published for opposition, I could raise my hand and say, hey, we're going to oppose this trademark. So I actually found these applications, wrote her a cease and desist letter, and she was basically like, yeah, neener, forget it. I have a trademark applied for. And I was like, no, we're not doing this. So my client there were two trademarks, right? There was a logo mark for adventure coaching and a word mark for adventure coaching. And we had to oppose both of those trademark applications. And it ended up costing the client, I think it was about $20,000 for the two. So there's a procedure when the trademark office approves your trademark. They basically say, yes, we approve your trademark, but we're going to publicly announce it's called the official gazette of the trademark office. We're going to publish it in the official gazette so that everybody else can see it too. That opens a 30-day window where anybody else can raise their hand and say, hey, I object. So during that 30-day period, I raised my hand on behalf of my clients and said, we object. And so it started it's called an opposition proceeding, which is like a mini litigation before the Trademark Trial and Appeal Board, not in federal court, but before the Trademark Trial and Appeal Board, that basically litigates who has the better rights. Okay, so they actually hired me to do all the filings, write the brief. Okay, that was about $10,000 just to like initiate this because there was a lot of research that I had to do. Why did I have to do so much research? Because my client didn't have a trademark on file that proved their rights. We had to go back and like dig through a whole bunch of stuff. It was, yeah. Anyway, Little Miss Infringer ended up not responding, but we still had to initiate all of this. And the filing fees alone were $1,200 for each opposition because it's $600 per class. Okay. So if you have more than one class represented in the trademark application, you're going to have a bunch of, I just filed an opposition for a client. The fees were $2,400.
Wow.
Just
Alone.
Just the filing fees. That was just the filing fees.
That is crazy.
And it is crazy, but you have to do it.
And what are the chances that you had done that opposition motion within the 30-day window? Was that a newspaper publication or just something online that you saw?
It was in the trademark database. So I saw that she had filed an application. And then when I went into the file history to see what stage it was in the application, it said that the mark had been approved for publication. It just hadn't been published yet, right?
Crazy.
But there is another procedure. If you miss the opposition period, you can file a cancellation. But in order to file a cancellation, you have to have a registered trademark. So what if your person is squatting on the trademark? They could squat for 3 years, right? Until they prove their use and you can file your opposition. I mean, you can really screw yourself over. I hope it's okay that I say that. You can really mess things up for yourself by not filing your trademark in a timely manner, because it basically just leaves the door open for other infringers to come in and say, ooh, that sounds like a good trademark. I think I'll register that, And people do. People will monitor the trademark database. And then once you file the trademark, they will go in and snatch up all the social handles. They do that too. So people are monitoring the trademark database. They know what's going on. And they will use it to create mischief for you if you don't sort of head them off, right? So if you're using a trademark and you like your trademark, you can keep your trademark, but you better register your trademark, right? So
yeah, and I'm thinking, like, what about the people that would also get the GoDaddy domain for it as well and just sit on that domain?
Yep, that happens too. I tell my clients, listen, before I file this, get all the social media handles you want. Get all of the domain names you want, right? Like whatever you want, let's get it now, because after I file this application, it's public record. People are monitoring these things and they're like, oh, really? And I'm like, yep. So if you have social media handles you want, get them now. If you have URLs you want, get them now. Because once we file a trademark application, if it's a cool trademark, people are going to go gobble up all those things and they'll sell them back to you later for a price,
All of this is so good to know. I don't think people realize what's going on out there with this kind of stuff.
No, they don't. They don't realize just how shady people are. Okay. Like people are really shady and they'll do all kinds of shady stuff. And, the only way to protect your trademarks is to register them and use them properly. So
you heard it from Angela right there. Angela, let me ask you this too. Copyright war story. What have you seen on that end of things?
Probably a little bit less than the trademark stuff, just because, okay, so, there's like people swiping other people's blog copy and people, here's one. I had a client, again, no names. My clients deserve their privacy. He sent out a long form email. Somebody on his list actually took the entire email, like changed 3 words, and then sent it out to his list same day.
Wow.
Somebody who was on both lists receives it from guy number 2 and then rats out guy number 2 to guy number 1. Guy number 1 is my client, right? Guy number 1 comes to me and he's like, this so-and-so just stole my email copy. Like the day. And I was like, oh my God, you got to be kidding me. So I wrote a very strong cease and desist letter to guy number 2. Guy number 2 never replied, but he also never did it again. And my client, guy number 1, famous copywriter, by the way, if you do any copywriting at all, you would know guy number 1. He actually posted my letter on his website and said, if you copy my stuff, I don't think he said stuff though, I think he said something else, I won't say, you're going to get a letter like this from my attorney. And I jokingly called it the heads on pikes letter, right? Like when the marauders are coming into town, they put all the defending army, they put all the marauders' severed heads on pikes, right? To like scare them. It's like, this is what's going to happen if you come into our town. We're going to cut your head off and put it on a pike. Yeah. So guy number 1, like he posted it on his website. I don't know if it's still there or not, but I call it the heads on pikes letter.
That's great.
Nobody copies his stuff.
Yeah, there's so much that people aren't thinking about with this kind of stuff. And all your work is creative. So you're really just trying to protect it. Yeah, copyright is a definitely different world. I remember that with like music copyright, with all the licensing and all the copyrights that would come from music artists and the labels, right? As soon as the artist makes that song, but they're bundled under the label, they, now there's certain rights that they can't use separate from the label. And so there's so much with that. Crazy. Angela, definitely a masterclass on trademarks, copyrights, for that really narrow niche of just that real estate, what people have to know, and how they can better protect themselves, right? Yeah. Better protect yourself with your content, courses, videos, photos, you name it. That's super important. Oh, yeah, Teresa's watching tonight. Look at this. We do a roll call usually at the end of the show. Teresa's watching. Teresa, I'm sure you're learning a lot with this. Very different topic, right? Angela, we're usually either having like a land or Airbnbs or, but this is like a pivot, something different that we have on the show that's really different. Michael Robertson, he said, I've been at real estate for 30 years. Al will help us do many more deals. Yes, Michael. Wow. I love it. I love that. My producer, Michael Williams, he said, have we trademarked POP yet? So there's a saying that a lot of people call me by. It's Prince of Probate. So they call me the POP.
Oh, yeah.
Yeah, we haven't trademarked that.
Well, maybe you should. The Prince of Probate.
Look at that.
It's very catchy. Yeah.
We'll do it live, right? No, now it's now it's public, right? So everybody's on notice. And Dan said, "What's up?" I love it. He's watching tonight too. So if you have questions for Angela when it comes to anything on trademarks, copyrights, how you want to better protect yourself, maybe you have an idea right now when listening to the show. That you're thinking, well, wait a second, I need to execute on this. I don't want to put this out in the public domain yet. I don't want other people touching this. Or maybe you're going through a situation where you see somebody else using that trademark or that logo or that creative ad. This is where you have to get the experts involved, an attorney like Angela that can really come in, do this. And that's what's really important. And we're going to keep putting the chyrons up where you can find Angela, all her information, the Instagram, and yeah, we have all the stuff there. Mike will keep putting up. Angela, so I've been doing a segment at the end of my shows called Signature Questions. Okay. We didn't go over this. So
you're going to surprise me?
Surprise. Yeah, I love it.
Let's do it.
So 3 questions, and we'll go one by one. What qualities do you believe make up an effective real estate professional?
An effective real estate professional. I think effective real estate professionals are persistent and they have integrity. Now, there's a lot of people aren't going to like that I say this, but there's a lot of people in the real estate space who are a little bit shady. And I think you can really set yourself apart if you have integrity, do what you say you're going to do, and you're persistent. You follow up, you follow through. Like those things are very important, especially on the client side, right? So when I've hired people to help me with real estate matters, I really care that, they follow up with me. Like, don't just abandon me after the lease is signed and allow me to do the inspection by myself, right? So I think those are two really important qualities, Al.
Yeah, when I picked the question, I had a feeling you were going to lean more to that integrity, ethical side, right? There's a lot of people leave that word ethics out, and
Right.
ethics has to be a huge part of being a real estate professional, right? That's
Yeah.
got to be up there with integrity, right? Just right up there.
Right.
So great answer.
Absolutely.
Angela, how do you stay organized and prioritize things in your business?
Um, I use a tool called Trello. I don't know. A lot of people might use it. It's kind of like, I think Monday is a little bit like it. If you've ever used Monday, it's like Asana. So it's basically like boards where you can move stuff around, and it helps you prioritize things, and it syncs with my Google Calendar. So it reminds me of deadlines, right? Like we don't want to miss those trademark renewal deadlines, Al, or
Right.
those response deadlines. We got to keep up with those. My practice is very deadline oriented. So it's really easy for me to set deadlines, set reminders, make sure that things show up in my calendar when they're due. It sends me email reminders. It's great. I really love Trello. It's wonderful.
Yeah, I've heard of Trello before. I don't use it myself, but having something like that can implement with like Google Calendar and
Oh yeah,
use it on your phone. Um,
lifesaver.
yeah, I'm sure, and it'll like ping you. I'm still in the era of the sticky notes. I still love the sticky notes because
Well, it's kind of go ahead. I'm sorry, I interrupted. It's
no,
terrible.
go for it.
It's actually kind of like sticky notes, right? Because when you open it up, you have a board, right? Think of that as like your whiteboard with the sticky notes on it, and then you've got lists. So you can think of the little individual cards as like sticky notes. So I can take the card and move it from this list to that list, right? Like a sticky note, right? So it might be like, here's the things I need to do today list. And once I finish with those, I'll stick them in someplace else. So when a client comes to me and they're a new client and I need to file their trademark application, it's there. And then once I file it, it goes into the list with filed applications. And then when I get a response from the trademark examiner, it might go to a different place, right? Or if the client says, I want to abandon this, I'm going to send it to the dead mark list. So
Right.
It's actually a really great tool, and it sort of frees you up from the sticky notes. I mean, gosh, what if your kids get into your office and they like rearrange all your sticky notes, or they fall off, or I don't know, right?
Yeah, and as lawyers, I mean, you have to stay organized and prioritize things, right?
Absolutely.
As business people, you have to do the same. And you have to have these tools. Like that's why I really wanted to pick that question out for you because in our business as entrepreneurs and business owners, that is fundamental. And if you're helping people get ideas to how they can stay organized when they're scaling their business or just keep growing their business. So I love that answer. Angela, you'll like this one.
Okay.
What is the hardest part of your job?
The hardest part of my job, honestly, is sometimes getting clients to give me what I need to do my job, right? So the client might say, oh, hey, Angela, I want to register this trademark for these goods and services. And I'll say, great. Here is, because it's very important to list the proper goods and services on the trademark application. And I want the client to tell me, yes, I approve the list. So sometimes I'll send the list off to the client and then crickets. Right? That was my cricket noise. I can't really do good crickets. Sorry. Okay, so then crickets. So of course, Trello will remind me a week later, hey, you need to get this approval list from the client. I'll email the client again. Hey, I'm just following up last week. I can't file your trademark application until you approve the list of goods and services. Would you kindly get back to me? Crickets, 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 right? So then I call them. Hi, this is Angela, your trademark attorney. Could you please, I sent you an email. Are you getting my emails? Oh, you're not getting my emails. They didn't whitelist my email address, so they don't know that I am sending them emails. Like I've sent them 2 or 3 already, and I'm like feeling a little cranky about it, right? So I call them up and I'm like, hey, are you getting my emails? Oh no, I'm not getting your emails at all. I'm like, okay, go check your email. Please look for an email from me because I can't file your trademark application until you tell me the goods and services, because we can't just not put the goods and services in the trademark application, right? Like that's an essential part. So yeah, just getting clients to give me what they need is sometimes a little bit difficult.
Yep. It can be difficult, and it just takes that follow-up, but at least you have like a checklist together, right? Like
Yeah,
you have an itemized list of, hey, been here, done that. This is what we
yeah,
need. You get this, then we can get moving. And
yeah.
that's really what helps you be efficient, makes your role even easier.
You know what else I did too is I actually made myself a bunch of email templates, right? So if my client is getting their trademark certificate and I need to send that to them, I have an email that I send them that tells them everything they need to know about renewing their trademark, how to use their trademark, blah, 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 blah. I only had to write that email once and I send it, and it always says the same thing, which may seem kind of like I'm processing my clients, but really I just want to make sure I don't forget to tell them anything important, right? I want to make sure that every client gets the same essential information that they need to know about the renewal, which I'll remind them of anyway, but I want them to know, right? It has to be renewed, and you'll hear from me on year 5 because we have to file the renewal, blah, 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 blah. So I want to tell them everything they need to know about the care and feeding of their trademark so that, they know how to use it and they know where to put the TM or the R or whatever it is we're using with it. It's really important to me that my clients get that information because it's essential to their proper use of the trademark.
If they want to get what they're looking for, they have to provide this information. Otherwise, they're not going to get there, right?
Well, no, they're already there, like they're registered, but I want to make sure that they know how to use their trademark. So I've like systematized all of my emails so that I don't forget to tell my client anything important, right?
Got
so
it.
that helps me a lot.
That works. Hey, another system and process right there, right? So that can help somebody with what they're doing.
Yeah.
So Angela, I think it's fantastic. I really find the topic that you get into interesting, and you're an expert in that niche, and I love that. I love that in family how useful this is for a lot
Mhm.
of the coaches and students and people that get into content
Uh-huh.
and why it's so important. And I just think that it's going to bring an awareness level to people that are listening to the show
Yeah.
on what their brands and images are going through and how to better protect it and what they're doing.
Yeah,
So
for sure.
just got to say thank you so much for coming on the show and taking the time to give us this expertise that's just so valuable. And as I do at the end of the show, I do a segment called Final Words, Final Thoughts. Anything that you like to leave the audience with is parting words, one word, a sentence, something that you haven't talked about, just that
Okay.
last segment. So as I do, final words, final thoughts, Angela Langlotz.
Well, your trademarks are a really important part of your brand identity. And if you would like to keep them for yourself and prevent other people from using them, it's a good idea to register those.
That's it. We got it. We got the whole point of the show right there. If you're not doing that, oh boy, right? Now you're going to really need the lawyer to come in. So, Angela, it's been so fun. Thank you again.
Thanks, Al.
Fun Wednesday night and just jam packed with information. I'll see you at family in about 2 weeks. It'll be a blast.
Ooh, yes.
I'll
Bye,
see you there.
Al.
Take care. Have a good one. Okay. Wow. Masterclass on trademarks and copyrights. I bet a lot of people didn't see that one coming, Mike. Just a completely different episode, right? Where we're starting to learn about things that we're not thinking about with just doing single family or land or a deal. Like, these are things that are essential for our businesses and protecting ourselves and our ideas, and making sure that, hey, if somebody else comes along and tries using it, are we protected? What do we do? And whether it's on the trademark side, the copyright side, Angela really broke it down on really what you got to do, what the differences are, what to look out for, and the importance of having somebody like Angela on your team when it comes to this. And all her information was put up through the episode. If you missed any of it, go back and check this out, right? Whether you're doing videos or YouTube or any sort of branding, this is just going to be useful to you. Or if you're even thinking about jumping into any of the content game, or setting up websites, setting up any kind of ad copy, this is huge. Don't miss it. And check us out on the social links, scan the QR code. And just got to say to everybody, thanks again so much for coming on, interacting, and I hope you all get value from these episodes. That's the hope of the Al Nicoletti Show team, is that we want to provide the value back to you so you all can succeed and level up your businesses. And next Wednesday night is another great one. We'll see you here Wednesday night, 9 p.m. Eastern, with the one and only Tom Barry. It's going to be another banger on the Al Nicoletti Show. I'll see you then. Have a great night, everybody. Take care.